Yes, good evening to everybody. Welcome to the family law class, and that is the Muslim law that yesterday that I dealt, the codicil as well as the domicile. These are the things which I dealt, and in this class I am going to deal the probate. Please read what I posted on the screen so that I could know that you are
Probate,
with me.
letter
Yeah.
of administration and succession certificate.
Yes, probate, letter of administration, and succession certificate. If you happen to see your syllabus, I don't know whether you've seen the syllabus or not. Do you have the syllabus with you?
Yes,
Okay.
sir.
Yeah. Is it the same thing that you have, which I'm showing over here? See, the remedies under the Divorce Act 2001, domicile, codicil, probate, and letter of administration, succession certificates, kinds of wills, interstate succession of the Christian and the Indian Succession Act 1925. Or the last this we covered the earlier silent feature of the Special Marriage Act of 1954. So this is what we found on the net. And I don't think whether you have the same thing or not, but I do have this thing with me. There I could not see, only I saw the only domicile, there is no codicil is there. Even there is no probate and letter of administration, even the succession certificate. But there is the interstate succession of the Christian and the Indian Succession Act 1925 is there. But anyway, that what I came to know from the relevant sources that what is posted on the what is a web, I mean net, that would be the quite correct one. That what I heard it. But anyway, that you compare it and you tell me whether you have or not. But still, it is not only one class that we are going to make it out, but one should have to know it. What is the probate is there? Yes. Do you have any idea about the probate?
Probate.
See, these are all the things. When a will is left by a testator, whether the will is a valid will or not, or authentic will or not, or genuine will or not. So we have to. It should be ascertained by the court. That is called probate. Let us see that according to the section 2, clause F of the Indian Succession Act 1925, probate refers to a copy of the will. It is a copy of the will that is certified by the seal of a court of competent jurisdiction. Here, competent jurisdiction court means where the testator is residing and in which court is having the jurisdiction at the residence place, that is said to be the competent court of competent jurisdiction. For instance, the testator left a will in what I say, any street like Kashmiri Gadda in Karimnagar, which is near Raitu Bazar. So naturally, which court is having jurisdiction at that place, that court will have the court of competent jurisdiction. So that court will decide it, take the copy of the will, and they will see it a genuine will or not, or fake will or not, or lost will or not. Then they will put the seal on it. So that is called the probate. Means certifying the will of the copy by the seal of the competent court in the particular jurisdiction. So that is the probate. Through probate, rights and pertaining administration of the estate is granted to the applicant who is an executor on the will. So with this probate, a executor would be there who will execute this will, because generally the executor will be appointed by the testator himself, or sometimes a legal heirs also or beneficiary also be one of the will be in the list of the executors. Even sometimes, even the testator himself, testator will not be executor over there, because the will be operate only after his death. Are you following me?
Yes.
Yeah. So it is a judicial process through which the validity and authenticity of a will is determined by the court of law. So we have to process it, we have to apply to the court of the competent jurisdiction, and to see that whether the will left by the testator is a genuine or not, and the competent court will ask it. But anyway, that one thing is very clear. See, if the will is written over there, naturally when the court it reaches to it, the court will publish in a public notice stating that so and so person left the will and this property goes to the so-and-so, this property goes to the so-and-so. If anybody is having any objection, they should bring to the notice of the competent court within the 45 days. So that public notice will be published in the newspaper of the particular area where the people will read that newspaper. Suppose in particular area, the people will not read Malayalam or Marathi newspaper or the Urdu newspaper. If you publish in the Urdu newspaper or Malayalam newspaper where the people could not read it, that is useless. So publish in the newspaper in that language which where the public at large will read in that locality, in that language one should have to publish it. So in this process, the executor of the will or the beneficiary and the value of the estate are determined. See, who is the beneficiaries here?
Legal heirs.
Repeat.
Legal heirs, sir. To whom the legal in beneficiaries, sir, legal heirs.
See, the beneficiaries are those persons to whom the property goes
Ah.
through the executor. It may be the legal heirs, or I told you also, even a stranger also be the beneficiary. Are you following me?
Yes.
Because he did the last services and he is the neighbor. She or he took a lot of pain when he was childhood, so he wants to give some portion to the that lady or that man also. So he will be the beneficiary. So generally the beneficiary are the legatees, and whose name was there in the will. A value of this estate are determined. So the executor will execute the will because the court will give the permission to the executor to decide and divide as per the will. Probate helps the executor to receive a certification from the court that is duly authorized to administer the estate of the testator. See, the court will get a letter to the executor that yes, now you can proceed it. Nobody could challenge it because it is already, they published in the newspaper, 45 days are over, nobody made an objection, then the will is a valid will, and no demands would be there from any person, and no objection has come over there, then you can proceed it. So that letter will be issued, that is called the letter of probate or probate. So even a beneficiary can be appointed as an executor under the will. I told you, even a legal heirs or a beneficiary can also appointed as a executor under the will also. So now, to whom the probate cannot be granted? See, the probate cannot be granted to certain people. Who are they? Generally, a person incompetent to contract, that is a minor. A person who doesn't have the sound mind. Are you following me?
Yes, sir.
So, according to Section 223 of the Indian Succession Act 1925, probate cannot be granted to any person who is a minor, very good, and is of unsound mind, it is obvious factor. Neither it can be granted to an association of individual. So, association of individual cannot be granted unless it is a company. If the company is there, yes, it can be granted, which satisfy the condition prescribed by the rules to be made by the notification in the official gazette by the state government in its behalf. So, where the official gazette notification comes and satisfy all the conditions of the company, yes, a company can be executed, but not the association of the individual, but not a minor, not a man of unsound mind, not a octogenarian. Who is this octogenarian? Yes. If you know it, you tell me. If you don't know it, say pass on.
Pass on, sir.
Octogenarian in the sense, octa means 80. Generarian means a person who is living in that generation. Means a person having the 80 years old. Because generally the person is having the 18 years old, we deem that he doesn't have that much mental maturity, number one. If the maturity is there, but he will be the childish more, because when you grow old age, you will become a child. Are you following me? Senile. Do you know what is meant by senile? Do you know what is senile? See, here I mentioned. Read.
of a person having or showing the weaknesses or diseases of old age, especially a loss of mental faculties.
Yes. The loss of the mental faculties would be there. A person having the more than 80 or 90 years old and old age because of the disease and various other factors would be involved over there, engulfed over there, then succumbed over there, then he becoming such a senile, then we can say. How do you pronounce?
Senile.
Senile. Senile. So that is the way of the pronunciation. Even octogenarian also doesn't have any capacity to be a probate executor. So now let us go to the point again. Letter of administration, what it means. Yes, the critical difference between the probate and a letter of administration is that probate is granted to an executor nominated under the will. Okay. Who will nominate the executor?
Testator, sir. Testator.
Testator will nominate the executor under the will. Even a legal heirs can also be an executor. Whereas if your will does not nominate an executor, suppose there is no executor at all, the beneficiary of the deceased will have to file. Who are the beneficiaries? Legatees, the legal heirs of the deceased will have to file a application for the letter of administration to the court. Which court? Competent court. What is meant by competent court? The court where it is situated, where the testator resides, where the legal beneficiary resides in that jurisdiction. Yes, this letter of administration would grant the same administrative right to the beneficiary that an executor would have enjoyed it. So, when the executor is not appointed by the legator, I mean the testator, at that instance, the beneficiaries or the legal heirs will file a petition in the competent court to appoint a executor, that is called letter of application for the letter of administration. So the letter of administration would grant the same administrative right to the beneficiaries like an executor. An executor would have enjoyed it in the probate. In the probate, executor will enjoy it because the authority will be given by the court to the
Beneficiary.
executor at the time.
Executor.
When will is written, when the executor is nominated, when executor is made by the testator, when there is no executor, the beneficiary will approach the court to nominate a beneficiary as an executor. However,
Sir,
if a person
Sai Rishita is waiting, sir. Admit her, sir.
okay, right, admitted. Because I did not see it. Because of course, I saw the notification there. Okay. However, if a person dies, intestate, then an applicant seeking administrative right pertaining to the deceased estate files for the letter of administration. So another point is, however, if a person dies intestate, means what it means? If a person dies intestate means
If he dies without writing a will.
without writing the will, if a person dies over there, then an applicant seeking administrative right means the legal heirs or beneficiaries or who are maybe or kith and kin, very close relatives, will approach to the application, make an application in the competent court seeking the administrative right pertaining to the deceased estate, files for the letter of administration. Hence, when a person dies intestate or does not nominate an executor under the will, it is then the letter of administration act as a facilitating document. Did you know the difference between the probate and the letter of administration?
Yes, sir.
Explain.
Probate is a copy of the will, sir. Which is given to the executor to be executed after the death of the testator.
When the testator appointed the executor, at the death of the testator, the executor will write a letter, petition to the competent court to see that the will is the genuine will and it will be stamped by the competent court. Then the court will issue a letter or an authority to the executor to administer as per the will. That is called probate. when there is no executor appointed by the testator, number one, and the testator dies without a will, writing the will, at that instance, any person who is relative to the testator, including the legal heirs, or anybody, but not the beneficiaries are not there. Why the beneficiaries are not there? Because testator did not write a will. Is it clear? Is it
Yes,
clear?
sir.
So at that instance, any legal heirs will approach or any kith and kin will approach the court by letter. Then the letter of the administration will be issued to see that a particular person will be appointed as an executor or with the letter of administration, and or the court will deem fit to appoint one person to be an executor or administrator, rather we can say rather executor, administrator, to see that the property left by the deceased should be inherited as per the laws existing over there, and whether it is a Muslim as per the personal law, whether it is a Hindu
As per the personal
Hindu Succession
Hindu
Act,
also,
if it is a Christian,
Christian Succession Act.
there is no Christian Succession Act, Indian Succession Act.
Indian Succession.
Jains,
Hindu Succession Act, sir.
Hindu Succession Act. So, in that way, it can be made. Letter of administration acts as a felicitating the document. Letter of administration is granted to the beneficiaries after they apply to the court of law. Here, generally, the beneficiaries will apply it. Now, here, beneficiary means don't think they are the legatees, they are the legal heirs. Are you following me?
Yes, sir.
Yeah. After they apply to the court of law having the competent jurisdiction, letter of administration entitles the administrator to all the rights belonging to the intestate effectively as if the administrator had been granted at the moment after his death. So when there is an executor, we can say executor there. When there is no executor, no will would be there, then we can say administrator through the letter of administration. To do what? To divide the property as per the law. Is it clear?
Yes, sir.
According to the section 234 of the Act, which Act? Indian Succession Act, if the executor, residuary legatee, or representative of the residuary legatee does not exist, declines, is incapable of the acting, or cannot be found, then the person would have been entitled to administrate the estate in the case of the deceased dying intestate would be entitled to file an application for the letter of administration. Of course, yes, they have right a situation where one can file an application for the letter of administration. The same provision under the Act empowers any other legatee having the beneficial interest or a creditor to file an application for the letter of administration as the case may be. Even a creditor also can file application letter of administration because he is having the interest. What interest is the creditor is having? Yes? What interest the creditor is having regarding the testator?
Because he is getting the property, sir.
Not getting the property. The debt he is going to get it.
Debt, sir.
The debt he is going to get it. That's the interest he is having. Is it clear?
Yes, sir.
Okay. So to whom a letter of administration cannot be granted? The same point. Who are the not competent? Repeat. Why you are taking so much time? Minor cannot.
Letter of administration cannot be granted to any person who is a minor or is of sound mind, not to any association of individuals unless it is a company which satisfies the conditions prescribed by the rules of and it is not granted for minor and who is of unsound mind, sir.
You need not to write because I read it and I explained you who are not competent to get this either the letter of administration or They are probate. A person who is incompetent means a minor. Number 2 is unsound mind. Number 3, even a senile. Number 4, not a association of the individual, but a company, but he should be identified in the gazette. He should come on the gazette and following all the condition. These are the only person who will be entitled to be either the executor or
Testator.
no administrator.
Creditor. Administrator.
We are the only part we are making is probate, executor, letter of administration, administrator. No will, letter of administration. Will, executor is there, executor. Because testator is no more. So who will operate? Who will run the show? There in the probate, executor. No will, administrator. Who will make an application? Legal heirs or beneficiaries or kith and kin will make an application that my father, my person did not leave the left a will over there. Now the property would be there. It should be inherited as per the personal laws of the parties. If they are the Hindus, Hindu Succession Act. Christians, Indian Succession Act. Jains, Hindu Succession Act. Buddhists,
Hindu Succession Act.
Hindu Succession Act. Parsi, there is a Parsi
Indian
Succession Act.
Succession Act. Indian Succession Act, sir. Parsi.
No, there is a Parsi Succession Act is there. No, either Parsi Succession Act or Parsi Marriage Act is there. There is the act is there, special act is there. Please check it once again, if I may be wrong. So now, it is a mandate to obtain the private letter of administration. Answer is yes. Section 213, clause 1 or subsection 1?
Subsection 1, sir.
Why subsection 1? Can anybody tell me? Why subsection 1? Yes. Hurry up. I told you already the way. Because any Arabic numerals are there, it is a section, subsection. If small a and Roman 1 is there, then we can say it is a clause because there is a tail is there. If the tail is there, then we will make it out. If the tail is not there, we cannot make it out. That I made it very much clear. See, 213 will go. This is the 213. See, here right as an executor or a legatee when established is a section heading. Is it or not? Is it or not?
Yes, sir.
It is a section heading. This is chapter heading, part heading. This is part heading or chapter heading. This is section heading. When the section heading is there, and what is the numeral it is? What numeral it is? This one?
Roman. Okay.
No. Like this one. This one. 213. What number it is? Sir, Telugu
Number-
number, sir.
1, sir.
Arabic numerals. Arabic numbers. So this is the Arabic number 1. So it is a subsection. 213 subsection 1. When you say clause, I told you that. See here, section 66, subsection 1, and this is subsection 2, clause A, clause B, clause C, clause D, clause E, clause F. There are Arabic numerals. or Roman capital, or Roman small, or small alphabet? Tell me.
Small
Small
AB.
alphabet.
Small alphabets.
Whenever the small alphabet is there, whenever the small Romans are there, generally they are the class. Generally they are the
Class.
class. And it is independent. Another point is independent. See, here definition I give. See, in definition, this is the a tale, means explanation. What is explanation here? In this act, unless there is anything repugnant in the subject or context. Okay. But this A, B, C, B, double B, double small b, C, double small c, D, E, F, these are all classes. Because they are all independent. See, you read this one, it is nowhere connected with the anyone. Everybody is independent. For instance, you take codicil. A codicil means an instrument made in relation to a will and explaining, altering, and adding in disposition and shall be deemed to form a part of will. Or does it have any connection with the administrator? Tell me. Does it have any connection with the administrator?
No, sir.
No. They are all independent. See, India. India means territory of India excluding the state of Jammu and Kashmir. Does it have any relation with the executor?
No, sir.
That means whenever the class are there, they are independent and they will be represented with or represented by
Apostrophes.
what is that?
Apostrophe.
They are represented by. If you don't know, you tell me, pass on, I will give the answer.
Pasan, sir.
They are represented within the parentheses small a alphabet, small b alphabet, small 2a double a alphabet, or they will be represented by small Roman number. Is it clear?
Yes, sir.
Only Professor Hussain student will give the answer. I will challenge it. You ask anyone in your class, what is the difference between that and this? Okay, let us come to the point here. Here I made it very much clear that it is a must because 213 class 1 makes it mandatory for every legatee or executor to obtain a probate of the will or letter of admission with the will before they are tried to execute a will. Otherwise, the executor or legatee can't establish any right in a court of law pertaining to the concerned will and any state mentioned thereof. If there is no sanction by the competent court with the seal, everybody will question that man. In a simple words, an executor or the legatee can. Who is the legatee?
For whom the he is the beneficiary.
The beneficiary in the will is called legatee. A legatee may be a legal heir. A legatee may be.
Stranger.
Yes.
Stranger, sir. Stranger.
Anybody, even a neighbor's husband or neighbor's wife, neighbor children, are a stranger also. Okay. And to perform the testamentary operation, their respective roles, the disposition of the deceased estate, when they duly obtain the probate, what is this? Sign and symbol. Professor Hussain students will say
Vargule.
letter of administration from a court of competent jurisdiction. Exception to the mandate under the, okay, there are few exceptions are there when it will not be there. Section 213, subsection 2, read with the section 57 of the Indian Succession Act 1925, clearly carves out certain exception to the mandate under section 213, subsection 1 of the Act. For a better understanding, both sections are extracted below. Of course, 57 is given, certain exceptions are there where it can be followed. That is the provision of this part which are set out in the schedule 3 shall subject to the restriction of the modifications specified therein apply. That is the clause A, to all wills and codicils made by a Hindu, Buddhist, Sikh or Jains or on or after the first day of September 1870 within the territory which they said were subject to the lieutenant governor of the Bengal within the local limits of the artery. These are all nothing would be there. See, in presidency towns, a little difference would be there. But now there is no difference at all. Everywhere, anywhere, the same procedure would be adapted. So now, right as an executor legati when established, of course, the executor rights it is given in the Indian Succession Act also, and they will give that what it would be there, section 213, subsection 2 and 57. They have given what are the powers and functions of an executor as an administrator, and we have certain cases also. Suppose if the question is asked in a 15 marks question, then please refer the cases. If you want, you can take the screenshot of this case. Otherwise, you can also see when you are looking at
Sir, our exam date came, sir, from 7th to 11th, sir. Our
I
exams.
am finishing your class by 2 days, within 2 days.
Okay,
When's
sir.
your exam?
7th, sir.
7th Sem. What is the
7th.
date today?
31st.
31st. How many courses left? How many chapters are left? There is no chapters are left because I already completed. See, the syllabus is concerned.
Only diverse Hindu diverse act something.
No, already I completed. It is only the interstate
Muslim
succession of the Christian and the Indian Succession Act only how to teach. I repeat, only one. Tomorrow will be the last class. Or day after tomorrow will be the last class. Interstate succession of the Christians and the Indian Succession Act 1925 how to teach. Otherwise, everything I covered. I repeat, everything I covered except this. And this I can complete it tomorrow. If it is not, after tomorrow is the last class. So I will say the bye because I am going to teach today onwards the law of thought. Today class is 7:10 to 8. If anybody wants to hear, including yourself also want to hear, you can join with us. I don't mind it. Okay, now let us come to the point of our study. It is there. Yes. So if you want to see the cases, the Clarence Spice and others versus Union of India, Supreme Court of India, Kanta Yadav versus Om Prakash Yadav and others, Supreme Court of India, Joginder Pal versus Indian Red Cross Society and others is also Supreme Court of India, Gangavat Lalu versus Gangavati Tulsi, High Court of Andhra Pradesh at Hyderabad, and Bhagwanji Karsan Bhai Rathod. I repeat, Bhagwanji Karsan Bhai Rathod versus Surajmal Anand Raj Mehta, High Court of Bombay, Hassan Raj and others versus Jeet Kaur, deceased High Court of Delhi. So now let us see what is the succession certificate. If once will die, then the property will go to the legal heirs, but they have to obtain the succession from the competent court or from the district judge or Tahsildar mutation. They have to come from the municipality also. And legal heirs. From there, again, it will be sealed. Competent seal will be given by the competent authority of the particular court. That is called the succession certificate. So, succession certificate is a sanctioning document that sanctions the right to inherit debt and securities to the legal heirs of the deceased who died intestate. This right to inherit is a sanction when the beneficiary applied to the civil court of the competent jurisdiction. In other words, a succession certificate gives a legal recognition to the right of a legal heirs to inherit the estate of the deceased. According to the section 370 of the Indian Succession Act, it is pretty clear that the succession certificate cannot be granted pertaining to any debt or security to which the rights are required to be established by probate or letter of administration. See, unless until there is a probate, a letter of administration, if these things are not over there, then the letter of succession will not be given to them, because the letter of certificate will be there, which are said to be the legal heirs, where the competent court with the stamp will endorse it. The succession certificate is not required in case of a compensation sanction for an employee's death. No. Compensation we need not to get, only the partition inheritance only we need the certificate. In the course of the duty, the Honorable Supreme Court has discussed the status conferred upon the grantee of the succession certificate in the Banarasi Das versus Teku Datta, Mrs. and others, where it is clearly mentioned only in the case of the succession certificate in the inheritance. A succession certificate intended to a note above the protect the debtor, which means that where a debtor of the deceased person either voluntarily pays his debt or a person holding the certificate under this act is compelled by the decree of the court to pay it to the person is lawfully discharged. The grant of the certificate does not establish a title of the grantee as their heir of the deceased, but only furnishes him with the authority to collect this debt to allow the debtor to make a payment to him without incurring any risk. Even a debtor can also will get the certificate because he's having his debt should be clear over there, and he will be the person whose amount should be paid before they are distributed to the legatees. So, after reading the decision of the Honorable Supreme Court, it can be easily construed that the succession certificate is helpful while dealing with the movable assets like a provident fund and a bank deposit, shares, loans, etc., but not a strong proof for establishing the administrative right pertaining to an immobile property of the deceased in a court of law. So, succession certificate mostly for the movable property, like I told you, the deposits and shares, loans, and these are the things where the succession certificate will be taken. Instrument like the letter of administration should also be supplemented for grant of administrative right pertaining to an immobile property. Where the immobile property would be there, it is the letter of administration will work more. Suppose you want to dispose the property. Suppose your father died, but there is no distribution of the property, including your mother and your children, brothers and sisters. Suppose you want to dispose the property of the father and take their shares. First and foremost, you have to do the mutation. You have to go to the municipality and see that you are the legal heirs and get the certificate from the competent authority, either the collector, district collector, or the mandal office or anything. Then you can file in the civil court. Then you say we are the legal heirs, and yes, each one get this much partition. Let it will be registered under the registration, land registration, and once you register it in each and everybody's document, later on, if you want to sell the property, join together, you will sign the and sell to the one person, because all 3 or 4 registration documents are there where it shows that you are the owner of the property. Now you are disposing the property without any compulsion. Are you following me?
Yes, sir.
Because the person who is going to purchase, he will ask, where is the link documents, from where you got this property? My father property. Okay, your father is no more. Yes, no more. Then who are the heirs? Mother and brothers and sister. Yes, whether the distributed mutation is over. Yes, if the mutation is over, then get it registered on each portion on your name. Then only all of you come and ask me to give the money. I will give the money at the registration office. When you put all your signatures, then it will be registered, then money will be cashed down over there. Because that is the procedure. So whenever you purchasing the immobile property, don't purchase only on oral basis. It should be recorded. Better you take an advisor, a advocate, a registrar, or a person who is working in the registration office, or even a munshi who knows more better than such things where the land disputes are concerned, where the land cases are going on, where the land registration is going on. Even the same land, it can be registered for the 4 to 5 members. Are you following me?
Yes, sir.
Yes, now you can check your syllabus, see which syllabus you are having with you. Whether the syllabus which I have with me, or there is also there that is domicile, codicil, probate, letter of administration, and succession certificate. That we covered it. Now only this portion is left. What is that? Read.
Interstate succession of Christians under the Indian Succession Act 1925.
Interstate succession means
Without a will, a testator died without a will.
without a will, a testator died would be there. Then how the Christians will get the portion under the Indian Succession Act 1925? That will deal it in the 2 classes. Later on, I will say the goodbye to you. With this, I would like to stop my today's class and meet you tomorrow. If anybody is interested, you can join in the law of tart, or at least inform them, those who failed in the examination. Okay, with this, I will stop and meet you tomorrow. Bye. Yes, leave meeting, choose a meeting, cancel, meeting to all, and meeting for all.